Herein we examine if being rude to a public servant causes forfeiture of all rights to redress, remedy, and due process of the people. Does being rude to the police grant the police full immunity to violate rights and immunity from redress? Does being rude after being attacked by police create probable cause ex post facto for the attack? Unfortunately, these questions are not attempts at comedy, but are relative to the true occurrences in the inferior court, constituting the need for appellate review. Did the inferior court err in failing to apply constitutional protections regarding filming public servants in the course of their duties from public? Did the inferior court err in failing to apply constitutional protections for speech? Did the inferior court err in converting a constitutionally protected right into a crime, claiming appellant committed crimes where no crimes were committed? Did the inferior court err in the misapplication of arguable probable cause? Did the inferior court err in demonstrating partiality? Statement of the case. Appellant was unlawfully arrested, detained, and harassed by police officer David C. Laird for recording police vehicles from a public area as a news story of public interest. The inferior matter, though based on well-established law, was dismissed by the assertion that 1. Defendants therein had reasonable, articulable suspicion and probable cause for detainment and arrest based on public photography, and 2. That defendants therein, as asserted by the magistrate demonstrating clear and present partiality, had reasonable articulable suspicion and probable cause based on the content of appellant's speech. That appellant's rudeness gave police full probable cause to attack appellant, and that rudeness creates immunity from suit. Summary of the argument. Appellant's unlawful arrest and detainment was a direct attack on the First Amendment. The Constitution and law set prohibition on the City of South Padre Island, Texas, from retaliating against appellant for First Amendment protected speech. The City of South Padre Island, Texas is lawfully prohibited from converting constitutionally protected free speech into a crime. This is not a new issue. Police commonly retaliate against free speech, and their disregard for amendment I result in powerful case law and costs the municipalities because it is always reversed. This constitutional abomination has now been extended for over 2 years, forcing appellant into this adversarial process for an extended time, where no defense exists for the unlawful actions of the defendants. Because saying, "Get back to work and go fuck yourself, old man," to law enforcement public servants is a right protected by law and constitution, the report and recommendations by the magistrate, adopted by the district judge, asserting appellant guilty of disorderly conduct by disturbing the peace for protected speech, not only affirms the unlawful retaliation by the defendants, but further attacks the First Amendment by criminalizing well-established rights. The asserted state statute violates the separation of powers and deprives appellant of due process under the law. In sum, the adopted report by the magistrate in opposition to appellant's constitutional protections are themselves a direct attack on protected speech and the lawful exercise of First Amendment protected conduct. Argument. Background. On Wednesday, October 14, 2020, appellant was in a public forum, a public parking lot behind a public police station bereft of any barriers, signage, barricades, fences, temporary or permanent notices that would make evident that the area was off limits to the public. Additionally, the area was absent any painted symbols or arrows directing the flow of traffic. There was no security booth where one must check in prior to entering, no signs directing members of the public not to enter or to enter only at the front entrance and not the rear, which was open and accessible, or to check in upon entering. Appellant entered the open passageway leading to the rear public parking lot behind the South Padre Island Police Department. This passageway, previously referred to as a breezeway, ROA 22 to 40,653.23, connects to another longer driveway, also unmarked and unrestricted, which connects back out to the public streets of the city behind the police station. Appellant operates a popular news channel on several media formats and began taking video recording of the openly displayed vehicles for public interest. Soon thereafter, several law enforcement personnel took notice of appellant and, from a distance, began yelling, asking if appellant required help. Appellant did not require help and, not feeling like screaming back, remained silent and proceeded to video record from the public setting all that appellant could see through his phone camera. As appellant continued with the lawful exercise of right, the said law enforcement personnel became visibly agitated and increasingly aggressive in their tone and demeanor, repeatedly asking what appellant needed help with and yelling, "SIR. Sir." Having ruined the news story appellant was attempting to record by the consistent interruption, appellant attempted to quell their curiosity and stated, "No, you can go back to work. Isn't that what I pay you to do?" At this time no crowd gathered, as the area was bereft of any civilians other than appellant. Appellant proceeded to record, and as appellant approached the end of the passageway to return to the adjacent public street, a clearly agitated and confrontational male police officer, later identified as David C. Laird, walked directly up to appellant and stood within inches of appellant's face, during the height of the COVID-19 outbreaks, and asked, "What was that?" assumingly referring to the comment I had made when confronted by the other officers. Appellant repeated what was stated, to get back to work. Laird responded, "I'm sorry, no, you're trespassing right now, and that's why I'm asking you what you're doing," despite being a public area where appellant had neither committed a crime nor been asked to leave. Appellant had stopped walking at this point, as appellant did not want to seem to be attempting to evade law enforcement personnel, and appellant stood still with appellant's recording device, a phone, still up in front of appellant's face, now recording the officer who had chosen to make himself the centerpiece of appellant's news piece. Appellant inquired, repeating back Laird's statement in the form of a question, "Trespassing on public property that I pay for?" "Yes," was Laird's immediate response. Appellant then requested name and badge number. Laird replied yes, but instead reached out and grabbed appellant's cell phone out of appellant's hand and dropped it onto the ground. Laird then grabbed by force appellant's right arm and began twisting it behind appellant's back. Appellant was then arrested by force and began speaking towards the cell phone that was lying on the ground saying, "Guys, go ahead and call the South Padre Island." That was all appellant could get out before being snatched straight up by appellant's left shoulder and spun around, twisting the muscles in appellant's back, by a very angry officer Laird, yelling, "Step over here. We're talking to you," as Laird pulled appellant off balance and forced appellant into an escort hold. Appellant was then taken without his consent and against his will to the front of a patrol vehicle and ordered to produce identification under threat of prosecution for failure to ID. Appellant repeatedly questioned the officer's right to demand ID absent a crime. Appellant argued back and forth with Laird, appellant constantly asking what possible charges existed and Laird stating, refusing to identify and, later, after appellant's release from custody and in response to appellant's question as to Laird's lawful reason to detain, "You were recording us." At this time, Laird went to have a discussion with a senior officer. This conversation was not recorded by appellant, but upon finally obtaining the body cam footage of the incident, after 8 months of opposing counsel, completely ignoring or opposing all lawful requests that they release it to me as per Texas state law, and with no assistance or intervention by the district court, appellant was finally able to observe the video evidence which shows Laird being challenged for his actions by the superior officer who asked him what had happened. Laird stated, "He was back here recording the units." To which the senior officer replied, "He's just recording?" Later identified as Detective Raul Hinojosa, to which Laird responded, "I'll cut him loose. I don't mind." When pressed by the senior officer, Laird truthfully stated that he had placed appellant in handcuffs solely for recording the units. Therein fully admitting to all of the allegations contained in appellant's complaint and summons, ROA.22-40653.22, ROA.22-40653.200. Arguable probable cause/reasonable suspicion. Appellant's right to liberty, to be free from government intrusion in the enjoyment of rights, was well established at the time of the subject incident as inalienable and unalienable. Appellant's right to be free from unreasonable search and seizure was well established at the time of the subject incident. It is well established law that for a law enforcement public servant to make any detainment, there must be a reasonable, articulable suspicion that the alleged perpetrator had committed, was committing, or was about to commit a crime as per Terry v. Ohio, 392 U.S. 1, 392 U.S. 29. Appellant was seized, by force, within the meaning of the Fourth Amendment by means of physical force or show of authority. His freedom of movement is restrained. United States v. Mendenhall, 446 U.S. 544, 553, 1980. No articulable criminal action had been committed to allow for lawful detention. Florida v. Bostick, 501 U.S. 429, 437, 1991. Laird seized and threw to the ground appellant's recording device without warrant and or probable cause. United States v. Cortez, 449 U.S. 411, 1981. Trespassing. It is well established that for a criminal trespassing charge to exist, one must be on private property, remain on private property of another without effective consent, and the person had notice that the entry was forbidden as per Texas Code 30.05. A reasonable law enforcement officer would 1. Know that anything paid for by public funds that is not barricaded, or that lacks no trespassing signage is open to the public, and 2. That for there to be a crime the alleged perpetrator must be asked to leave, and the crime only exists if said perpetrator stays. Here, Laird suddenly, and without warning or ultimatum, attacked, causing an unlawful and abusive detention based on the allegation of trespassing where the area was/is public. There was no signage to inform appellant that entry was forbidden, and appellant was never asked to leave. Appellant was arrested and detained for recording the units as retaliation to Amendment I Press. The assertion of trespassing fails to meet the reasonableness threshold of Terry to allow for detention. While police are not hired based on pre-existing knowledge of the law, a reasonable officer, who at least passed police academy, should clearly know what constitutes trespassing. Arguable probable cause was lacking as well as reasonable suspicion for the attack on appellant and appellant's God-given rights. Failure to identify.